From the main list, item number 1.
Sit down.
That exercise has been completed, Mr. Khan?
Lordship, not exactly, Lordship, for the simple reason that on 9th of this month,
Yes.
on 19/9, first of all, Lordship, we made a submission that there was some more.
Yes.
And Lordship, on inquiry, we found out the details. It's quite bulky and we have to get it typed. So we've just received on 9, Lordship. We just create the leave of the course. And some are handwritten even.
Yes.
So, Lordship, we need at least 3 weeks' time, Lordship, to. And there was another aspect in the order of 99. What is the situation of COVID death in the custody? Lordship, we have received instruction that 6 COVID patients who had died in custody, they were adequately 50,000 compensation was paid.
Very good. And they'll be entitled to the general compensation going to COVID patients?
Lordship, yes. 6 have been paid. 50,000 have been paid, Lordship.
15,000?
50,000.
Is that the benchmark set by the Supreme Court?
Lordship, yes. Even central government has put that ceiling in Lordship. So we are following that.
Is that 50,000 only? No, I think it's 4 lakh or something like that.
Yeah.
Just find out. Okay. I think it's 4 lakh as set by the Supreme Court.
We'll try to find out.
4.
It's 4 lakhs. It's probably 4 lakhs. Again, I could be mistaken. Just ascertain that. That you give and indicate to us that you've given. Furnish these details. Meanwhile, Brother Thank You and Brother Dingdo had visited the Shillong jail. There are some positive aspects. For instance, the food was adequate, the food was good, but there are some other aspects. It has over-occupancy.
Lordship, yes.
So that has to be taken care of in due course. We can't ask you to do it overnight.
Lordship, the annexure will
more importantly, and Brother Thank You will address you on that, is about the medical personnel.
Lordship.
Yes, thank you. You see, what happened that day was we had gone on Thursday. And when we got to the infirmary or dispensary, there are only 14 beds and there are 25 patients. So that has to be looked into. And the patients are sleeping under the bed. And I asked the doctor, said, no, they all need medical attention, so they've been kept at dispensary. Number 2 is the CCTV is still not functioning. And how can a security establishment have CCTV? Number 3 is we even inspected the new
construction.
Even those buildings will not be sufficient, to ask how much would they house, 130, not sufficient to house the population that's there in the jail. Another thing is the medical, the doctor is only one doctor, there's no male nurse, he's assisted only by 2 pharmacists. And so he can't take leave, so poor fellow. He's been there for over 4 years. So there must be some kind of, from the health department, they have to depute someone else. A junior doctor or a male nurse or someone who can be there. So another thing is with regard to these opioids that are given to the patients also. Now opioids, some of them they have a tea addiction program, and so how it's administered and all those things also they need I think more expert people, because they can conceal it, and then I don't know how to use it later on, and those things are there which the doctor was very concerned about. That those things are there. And he sits in OPD every day around 80 patients. He sees 80 patients. Some come, they have ailments. So those are the things, the health is very important, I think. Yes, firstly, and the CCTV is next, and the overcrowding.
Well, Lordship will consider this. Absolutely.
The state seeks a further 3 weeks to furnish the details in terms of the order dated September 19, 2022, both in respect of custodial deaths and deaths of inmates in correctional homes due to COVID. Full stop. Paragraph, let such details be furnished by way of an affidavit to be filed within 3 weeks from date. Copies of the affidavit shall be made over to Dr. Mozika, amicus curiae, and any other person represented in the present proceedings. Full stop. The matter will appear a week thereafter. A working week thereafter.
Oblige.
How many names do you have? Because Dr. Mozika has some details, and there are others also who are complaining that
My lord, as far as 38 names that came earlier, my lord, I prepared some sort of,
We have 10 new names.
and the postmortem report I've analyzed all that, my lord. So, if Lord says, please, we can start with some of the cases, my lord.
we will start with some of the cases. Before starting with some of the cases, we'll set the benchmark.
My lord.
The benchmark will be, depending on age, quantum of compensation. And then we'll go into the individual cases, whether they are entitled
The
to.
Lord says already reflected that.
That's tentative. That's
10
tentative.
lakh
That
rupees.
we've given them an idea. We'll give them a chance to, contest that or argue against that or suggest, as they may find from data in the rest of the country, that these figures are too high. Similarly, you can find out whether these figures are too low. We'll give something which is a national benchmark,
Rajasthan is 5 lakhs, Your Lordship.
which is comparable to elsewhere. Not any more than elsewhere, not any less than elsewhere.
Because what it appears is it appears to be an ongoing exercise, my lord.
Yes.
There will be deaths and there will be new matters coming up every now
But
and
we can't take it lying down.
then.
We have to make it a deterrent. This compensation will be a deterrent. Because, if you're paying 15 lakhs to 100 people, the state will bleed. So the next time, the state will tell its police officers to be slightly less brutal. That is the idea. It's both a compensation to them and a deterrent to the
They
state.
tend to the state, Lordship, absolutely.
So after 3 weeks.
Next, it has to pay you. No, sir, entire time compensation should be paid. Why should it be? If there is a point, then only I will pay. So, That one. All the engineers, everybody. Yes.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Yes. Just
in item number one
give us a
and-
moment, please. Give us a moment, please. This pertains to the airport.
Airport matter, my lord. They were supposed to submit a feasibility study report.
Are you in the airport matter, Mr. Nath?
No, my lord, I am in PIL item number 1 and item number 2, PIL
Yes.
8 of 2022.
Just a second. We are in supplementary list. We'll come to the main list a bit later.
My lord, I'm sorry.
Yes, Mr. Advocate, where do we stand? And Dr. Modika, both.
My lord, the pre-feasibility survey has been done, my lord.
Yes.
The team which came for the survey, my lord, they're analyzing the things, my lord. They're paying some more time, my lord.
Yes, it requires some more time because
Because what
they do laser studies, they do scientific things, and as long as
because this is the first study, my lord. Once this is successful, they have to go for OLS study. That will navigation things and other things, my lord. So we are praying for 4 more weeks time, my lord.
we'll give you 4 weeks, and in the meantime, can we quietly go one day
To see the site.
just the present airport?
Umrel?
Yes, the present airport with your previous report, because Dr. Muzika, I have walked the tarmac recently when I was flying out, and runway 21, it may not be feasible, but runway 44 extension may be feasible. And if that extension is feasible, we are talking of saving thousands of crores of rupees. Because we already have an establishment, we have to upgrade it. It will require, if runway 44 is extended, what it will require is for navigability, for the highway to be altered a bit, which is not as earth-shattering as felling a mountain.
We can arrange that. But my lord, earlier what has happened, we have examined the technical things.
What was supposed to happen over there was that in order to get heavier aircraft, you need to construct a runway which is suitable to receive that, particularly at the landing point, you know, when it first touches down. Now, for that, there are technical specifications, let's not go into that. You've got to dig at least about 10 or 15 feet and then start layering in them so that it can cushion that and there is no subsidence or anything. Even the slightest would imperil the aircraft.
Yes.
That was planned at Umroi. But when that was planned, they discovered that the length of the runway was not enough for a flight to touchdown, and when it could not properly land, to go and take off again. That was the main difficulty. Now, so therefore, and strengthening of the runway, the investment that is involved is huge.
Yes, sir.
Imagine that you're digging up a 2-kilometer stretch, and then you're filling it up with specialized material.
Yes, sir.
You know, so that's a huge cost.
My lord, but at one point of time, tender was issued for this, my lord, approximately 100 crore rupees, my lord. For the runway.
Yes. But then ultimately it was discovered that the runway may not have that feasibility. But runway, I don't know what they studied or what they did. But if you physically go with an appropriate, you know, tape and measure it, runway 44 is adequate.
Yes, Lordship. Last time also we did visit the airport, but there was obstruction about 5 kilometers from, and they were saying that there is a hill obstructing the, but if runway 44A we can explore once again,
the possibility, if that obstruction is not coming and it is feasible, then it is much cheaper and
It's going to be much cheaper both for the AAI and for the state.
Yes, sir.
But there are other interests which will probably not allow Mumbai to be developed and definitely not allow the new airport. You can take it from me, it will otherwise be feasible, but some scientific glitch will ultimately be cited to kill that project.
That is being cited, my lord. That last
Some
time
scientific glitch at the end will be cited. I can predict it for you. And there are specific reasons for that. Reasons that we cannot indicate. Because it will be 1/3 of Guwahati traffic which Guwahati will lose. And so much money coming into Shillong would be an immediate development. Forget everything else.
My lord, even this...
It's more convenient if a tourist can come directly to Mumbai and then stay at Umiam or some other resort which is close by and then make day visits to Shillong or elsewhere. It is such an attractive proposition which, going through the grime from Guwahati, some people do not like the twisted roads, hill roads, some people don't like road travelling.
In fact, we were discussing with Mr. Paul, he was of opinion that even the travellers from places like Khanapada or Beltala, rather than going to Guwahati airport, if they get a cheaper ticket from Mumbai,
exactly,
they
prefer to come over here and use the facilities.
Even the people, travellers from Nagaon side, they have to cross Jorabat and then...
Exactly. Instead of that, they'll turn left. They'll turn left. All your, the tea gardens around, where is that place? Where the Hindustan paper has that mill?
Nagaon.
Not Nagaon, but what is the name of the place? Jagir Road. Yes. Jagir Road and down the line. It's a huge thing, and as we said that both of you will have your statues outside the airport.
Even that cluster, what they're talking, my lord, where they say that we need to chop off the cluster 1, my lord, in that funnel approached, my lord, in the chart that they've given, they need to remove church, electricity, those towers and all. These are the only thing that was coming on the obstruction way. So I think if there are some expert to relook into whether it is really required to chop off the entire hill or just some obstructions that is coming on the funnel way, my lord.
The problem is that we are not experts.
My lord, that's why, my lord.
Number one.
Yes, my lord.
Number two, when an independent expert body has given
my lord
a report, ostensibly with no axe to grind, unless we find malafides in their approach, that direct malafides we cannot either allege or discover.
My lord.
But actually what happened, my lord, airport authorities is the executing agency, my lord. The actual approval has to be given by DGCA, my lord, which is statutory body now. Now when there are clear norms set by DGCA, my lord, that the flying gradient has to be 1 degree and 1.5 degree to certain kilometers, and there should be clear approach path, my lord. Now those hills are coming in the way.
at least one hill.
Now had it been otherwise, that is for extreme precaution, my lord, the DGCA has let down the norms. It is not that without that flights cannot land. Flights can land, my lord, but we cannot, because DGCA for civil aviation will not give that permission.
No, we also do not advise where any element of risk is involved should not be taken.
And the most important aspect, my lord, one side may be, but the flight, the norms are that if it for some reason it cannot land, the other side must be clear so that it can take off again, my lord, for passenger safety. That is not working out here.
And one of the hill, as per the report, is that 100 meter has to be cut down.
150 meters.
150 meters. That at that point of time, my lord. But if this new 44 big survey and the 44 the railway,
we are putting it to you. We have nothing personal in this. We are putting it to you. even if found feasible, your new site, it'll take at least 4-5 years
Yes,
for it
sir,
to ultimately be developed.
and huge amount of
A huge amount of expenditure you'll have to decide on, the returns and everything, make a cost-benefit analysis.
By examining one particularly strip of the airport, if that is feasible, then because we have already spent 50 crore rupees in chopping off and making it compliant of.
So that as the state,
Yes.
as the state, it's in your interest
Yes, sir.
that you ascertain
Yes, sir.
by engaging, experts as to whether runway 44 may be feasible and may meet the DGCA guidelines with much less cost than setting up a new airport.
Yes, Lordship. What my friend has said, my lord, that DGCA is the statutory authority. Otherwise, and that's the only authority which has got the power under the statute to.
Very well, very well.
So we can have the agency.
Let us say you are an expert structural engineer.
Yes.
All right? I want to build a house. Where I want to build a house, you say that the land over there is not suitable for a multi-story construction to come up.
Yes, sir.
So there must be some kind of an answer.
Yes, Lordship.
I am entitled to get a second opinion.
Second opinion, yes, Lordship. Second opinion.
And that second opinion, I will place it to you, and I will put one set of experts against your set of experts,
Yes, sir.
so that they can discuss it out.
Yes, Lordship. That exercise, because we
That
may
is something which
we may require to engage consultant, an international body to go into this aspect. At that point of time, it was also considered whether we can have the third party
Exactly. So
waiting by third.
it depends on how serious you are.
No, may not
It's
be-
not as if the High Court wants an airport.
I understand, Your Lordship. At that point of time also, when the proposal came, we cut down one hill and we spent 50 crore rupees. In 100 crore rupees, if the matter can be resolved and we can have airport, we will try our best to get it, my lord. And that, again, we will have a relook. In the meantime, whatever process is going on.
100 crore you are willing to spend, your new airport will not come up for anything less than 3,000 crore.
Yes, sir. Greenfield projects are.
Greenfield project will not be less than 3,000 crore, of which the AAI or the DGCA may have to spend probably the lion's share.
Yes, sir.
But your contribution over there will not be any less than 100.
Yes, sir. That will be there mostly
It
because
will be in excess of probably 500.
Yes,
It's
sir.
contribution only for land, malware and the road connectivity and other things.
Exactly. So when you are in a virgin place, even setting up the road, everything, that costs a lot of money.
And hopefully in future we will have better technology, better.
So it's for you to decide.
Yes, sir.
You know what you want.
Again.
At the end of the day, we don't want to impose ourselves.
Yes, sir.
It's not as if the judges will be better off if there is an airport, or
Yes, sir.
the High Court, gets a helipad if there is an airport over there. We are not going to want a helipad on our terrace.
I will be better off, my lord.
My lord, one aspect is there, my lord, all these, because this PIL is pending for many years, my lord. In fact, the chairman of Airport Authority of India, after examining everything, my lord, he himself surrendered, my lord, that this Umbro is not going to work. Airport Authority of India is ready for a greenfield airport. And for that, I think there is some much in principle approval, because Airport Authority, I think Meghalaya is the only state capital, Shillong, which is not connected to the national capital. So that should not be a problem. If you go back again to that, my lord, I do not know, my lord, maybe something will work out.
It's for the state to decide.
Yes, we'll
It's for the state to decide.
This
We are not
process-
stopping the new project. After all, they've gone ahead, they've also spent a lot of money, more than 30 lakhs of rupees they've released for the purpose of the assessment being done, the technical feasibility study being conducted. We are not saying that, but still, if the state were interested in exploring, we're just bringing it to their attention.
Yes, sir.
Parallelly,
We will sit with Airport Authority of India once again. We'll get the report and we'll try to have it weighted by third agency.
Up to you, depends on what you're.
We will try to do that.
It's a
Because
matter
we will say, because now recently.
in India there is no other agency who can do this.
In India, there may not be any agency, but DGCA is not the last word.
Maybe Army Authority or Air Force Authority.
DGCA may not be the last word. army authorities, for instance, but of course, army authorities have to compromise on several things. It's a discipline force, whereas civil aviation, you have to think of the last man in the wheelchair. In the army, there won't be anyone like that. So therefore, considerations are different. And we don't want to pit one authority against the other. So we are just making it known
Yes, sir.
to the state
Yes, sir.
that these are the bottlenecks that are going to come up,
Yes, sir.
and they are man-made. So they are man-made. So
In fact, we cited the example of Leh also. Leh is also one of the difficult airport. Leh is also one of the most difficult airport, and then the flights are going to Leh on.
the more difficult airport is Paro.
Paro, yes, in Bhutan.
More difficult airport is Paro.
Yes.
Paro, you have to make the P turn, and then you see the airport less than 1 minute. You see the runway less than 1 minute before you are supposed to touch down. So Paro that way.
My lord, even this aspect was examined, my lord. What came out, my lord, is that in Shillong we'll need instrumental landing, my lord, because of the cloud cover and visibility issue.
Absolutely, absolutely.
That is not the issue with Paro and even Leh, my lord. The visibility issues of the fog conditions and cloud conditions are not there, my lord. And those airports are visual airports, my lord, visual airports. And when the airport is converted into instrument landing, my lord, the safety margin or the
Much
buffer
greater,
is
much
much
greater.
my lord. That is what is creating problem, my lord.
Plus,
Had it been visual condition, my lord,
plus, you know, these, every time you try to land at Paro, just before you make the P-turn, the aircraft, because the aircraft specifications are different, will give you a warning, terrain ahead, terrain ahead. And it's, you override that warning and you land at Paro. Every time you land at Paro, it will give you the terrain warning thing, which every aircraft, it's built into every aircraft. You know, say 500 meters or maybe 1.5 kilometers from terrain, it will give you the terrain warning. It will give you, you know, if you are falling down or if you are close to the ground, it will give you that warning. These are inbuilt.
what I was told, only few pilots can land in Paro, my lord. That's what.
Only a few pilots can land in Paro. Only a few pilots. Since the Airports Authority of India says that a further 4 weeks' time will be needed to obtain the pre-feasibility study report conducted at the new site offered by the state for setting up a Greenfields airport project, not for setting up, for the Greenfields airport project, let the matter appear immediately after the vacation in January, 2023. Full stop. Paragraph, the report should be circulated to the state and to advocate for the petitioner a week before, a week prior to the matter appears in court.
My lord,
Because
just
4 weeks from today takes us to the holidays.
Drone photography has been done. We have completed drone photography, Your Lord.
Very good. The state confirms that drone photography has been completed. Yes,
my lord, that is what I wanted to point out. My lord. My lord. All right.
the other thing, Mr. Advocate, we had restrained the construction by the Umiam, but the one construction which is right next to the Jackwell pumping station is going on, has been resumed.
I'll look into that. I will look into that.
It has been resumed.
I'll find out. I'll check.
Item number 2.
May I please, Your Lordship?
Yes.
Lordship, in this matter, Lordship, the pleadings are almost, pleadings are complete, Lordship. Lordship may fix this matter for hearing, Lordship.
Yes, that's what we are here. What is the matter about, Dr. Monica?
Well, this is special rate of value addition in GST, my lord.
Yes.
Central excise. And there was a time frame for submitting the application of 30 days, my lord.
Yes.
But that particular notification went on challenge to the Guwahati High Court and then.
Oh, that's that.
My lord.
7th July or 3rd July notification.
My lord.
What is the date? Ultimately, the matter went to the Supreme Court.
My lord. And the notification was, initially the notification was set aside by the Guwahati High Court, my lord. On the ground of promissory estoppel, my lord.
Yes, and ultimately that notification was revived by the Supreme Court.
Revived by the Supreme Court.
By then, time had expired, and therefore we were dealing with what about those people who, because the notification had gone, could not apply,
My lord.
and what will be their fate?
My lord.
That is the issue involved
Exactly.
over here.
My lord.
What is the date of the notification? Get it from the judgment of the Guwahati High Court, operative part. 8 July 1999.
My lord.
8 July.
8 July 99.
Yes, proceed. Mr. Saikia?
Lordship, we are being led by Dr. Ashok Saraf in this case, Lordship.
Yes.
Lordship may fix this matter for hearing, Lordship.
It is there for hearing. We are ready to hear it straight away.
Lordship, in this case, Lordship, Dr. Saraf would be arguing this matter, Lordship.
Yes, get him. You start, let him come.
Lordship, he's on legs, Lordship.
Very well, since the petitioner seeks an accommodation, let the matter appear. 3 weeks since. Yes,
Soon after beginning.
yes. 3 working weeks since. Yes.
From the meanness, item number 1.
Yes, this is where you come in, Mr. Nath.
Malad, in the second item, Malad, I have received the papers. My lawyer friend for the petitioner has served the copies. But I am awaiting instruction in the second item, and I have received instructions in the first item.
Yes.
I prefer 2 weeks time, Malad, for filing my response in both the cases, Malad.
Since the state of Assam seeks a fortnight's time to file affidavits in both the matters, comma, let these matters appear 3 weeks hence, full stop, the state's affidavit should be filed within a fortnight and copies thereof made available, the state of Assam's, and copies
Yes.
thereof made over to both the petitioners and made over to advocate for the petitioners and advocate for the state of Meghalaya. Yes.
Private respondents.
Private respondents may also be served.
Yes, yes, obtain copies from them.
Much obliged.
We are specifying only these two, all of you are entitled to. Yes.
Item number 3.
May it please your Lordship. My Lords, we appear for the petitioners. I'm being led by my senior colleague, Mr. Saha. My Lords, he was on his legs today, my Lords. If I may request, my Lords, to kindly have it on another date, my Lords.
When?
My Lords, 28th November, if that's possible, my Lords.
8 December.
28th November, in 2 weeks' time, my Lords.
28 November, and something.
They want 2 weeks. It won't happen before the vacation.
my lord,
8th November, I will not be.
if December is possible, my lord, 16 December.
Let us see. 16 December we are closing.
Last working day.
My lord, 14 December if that's
Since
possible.
the petitioners seek a fortnight's time, let the matter appear. A fortnight hence. It will appear, thereafter we'll see what happens. Yes.
Obliged, my lord.
Item number 5.
My lord, in the earlier occasion, with your lordship permission, I have drawn the attention of my lordship to 1937 rules.
No, no, first,
2000.
we have now one compilation in two parts.
Yes, Lordship. First part is Scheduled District Act and second is Volume 2, Milord, index of Volume 2. But primarily we will be requiring Volume 1, Milord, the first part.
The first one runs into 176 pages. Mr.
Yes, I'm sorry.
Yes, my lord. That is the,
176 pages.
my lord.
And the second one runs into 158 pages.
My lord.
Or 160 pages.
160.
160.
My lord. So the first one is, my lord,
So for the moment, we are keeping everything else apart.
yes.
We are just yes.
We look at the first paper, my lord, compilation paper. Now, lordship, I'll not take long time, but I'll just try to indicate the acts only in the rules.
Just one moment, please. Yes.
My lord, page number 1 is the Scheduled District Act 1874.
Volume 2.
Volume 1, my lord.
Oh,
My lord.
I have made a mistake. Yes, sir. Continue.
Volume 1, page number 1, my lord, Scheduled District Act.
Yes.
And under Section 6 of that Scheduled District Act, local government was empowered to appoint the judicial officer. Section 2, my lord, page number 2.
Section
Section 6, my lord, at the bottom.
6. Local government may from time to time appoint officers.
My lord,
And who is the local government?
Governor, Milord.
Governor.
Governor.
Defined.
Not defined, Milord, by virtue of the Government of India Act and rules have been set. Government of India Act for what?
What was the Government of India Act before 1874?
Yes, 1854, Milord.
This is a regulating act.
Under that act, Section 3 said that by Section 3, Governor General in Council will be the local government. and time to time amendment was carried out. Ultimately, governor was declared as local government so far as backward tract or excluded or partially excluded areas are concerned, my lord.
So it is governor.
Governor.
And in that subsection P, my lord, the local government was empowered to frame the procedure.
Yes.
Now, in next, my lord, the schedule is mentioned. Lordship, you kindly come to page number 7, my lord. Chief Commissioner of Assam, my lord. So this, the tribal area at that time also fall under this act, my lord. Page number 7. Chief Commissionership of Assam,
Yes.
my lord. So the Khasi Jente Hills also under the Chief Commissioner of Assam that time. Now,
Chief Commissioner of Assam,
well,
what does Part 10 refer to?
Part 10 is not the book.
my lord, Part 10 is the Chief Commissioner of Assam, and there they have indicated number 1 at the bottom when we see.
Where is it referred to in the body of the Act?
Well, part 2,
Yes.
part 10.
Your Lordship will see page 8, and the second half of the page, annexure C3, Your Lordship.
8.
See, page 8, annexure C3, and the annexure C3, below that, reformation of the Chief Commissioner of Assam. Government of India Home Department Notification 291, dated 22nd March 1912. In exercise of power conferred under Section 3 of Government of India Act 1854 and with the sanction and approbation of Secretary of the State for India, Governor General and Council is pleased to issue the following proclamation. Following territories which are now included in the province of Eastern Bengal and Assam, namely so and so, and then your Lordship will see at the foot and the Surma Valley Hill District Division comprising the district of Kachar, Khasi, Jaintia Hill, Silhat shall be from the first day of April 1912 be taken under the immediate authority and management of Governor General of India, Council, and formed into Chief Commissioner to be called Chief Commissioner of Assam, my lord.
And this is annexed to what?
Annexure to book, my lord. This part we couldn't get it on the website, but it was in book, my lord. From book, my friend has taken out.
No, and every annexure will be annexed to something.
Yes, sir.
Where is the main book?
Scheduled District Act.
Well, Scheduled District Act, my lord.
So where does it refer to annexure A, B, C? Where does the Scheduled Districts Act refer to this?
My lord, in the compilation authored by Justice Hansaria, my lord, it is in the District Council. This sixth schedule compilation.
What my friend is saying that Mr. Hansaria has compiled the book. In their book, it is referred to.
There it is referred. After some time, may I please, my lord? I'll just request.
No. We are looking at one compilation. We are not looking at stray papers. That's what we are. We've been adjourning the matter for days together.
Right.
We are looking at one thing.
Right. That is true. That is true.
What does the schedule mean? In the Constitution, there is a schedule. That schedule has reference to in some article.
Yes.
In any law, there is a schedule. That schedule has reference to a section. Where is the reference? How to read the schedule? In the body of the Act.
Yes, Your Lordship, kindly come to section 1.
My lord.
local extent. The Act extends to first instance to the whole of British India, other than territories mentioned in the first schedule hereto annexed, and it shall come into force in each of scheduled district on the issue of notification under section 3 relating to such district. Interpretation clause. In this act, the term scheduled district means the territories mentioned in the first schedule hereto annexed, and from date fixed in the resolution next hereinafter mentioned, it shall also include any other territories to which the Secretary of State for India by resolution in council may declare the provision of 33rd Victoria Chapter 3 Section 1 to be applicable. And then 3 Miller.
Enactments maintained in second schedule here to annex shall be repealed. So the second schedule has only one,
Yes, Your Lordship.
which is the 1869 Garo Hills Act.
Yes, Your Lordship.
So we understand second schedule is repealed.
Yes,
Why
sir.
does the second schedule, oh very well, there is section 2. Now, where do we get annexure, where is the reference to annexure C3?
C3, page number 8, my lord.
Where is the reference in the Act to annexure C3?
Now, my lord, this notification is by virtue of notification under section, the power conferred under section 1, my lord, and this is under 1854 Act, my lord. If your lordship will see, Government of India Home Department Notification 291 dated 22nd March 19, in exercise of power conferred under by section 3 of Government of India Act 1854.
No, sir, just, it may appear quite idiotic to you, but just come to this. Come to the page 7 that you have annexed over here.
Yes, Your Lordship.
Right on top, see the Scheduled Districts Act 1874.
Yes, Lordship.
There is a heading on both pages.
Yes, Lordship.
Even on the two reverse pages, the heading is Scheduled Districts Act 1874.
Yes, Lordship.
So therefore, whatever annexures you are showing, the second schedule, annexure A, annexure B, annexure C1, C2, C3, are all part of the Scheduled Districts Act.
Yes,
Now,
sir.
where in the Scheduled Districts Act have they been referred to?
Yes, sir.
It's not as if these are subsequent documents
Yes, sir.
which have been brought about by virtue of the Scheduled Districts Act. These over here indicate that they are part of the parent act itself.
Yes, Your Lordship. Your Lordship is right. What it should be, because at the bottom of the page 8, it says published in the Assam Gazette.
Very well. The notification creating Chief Commissionership of Assam 1874 is annexure C1.
Yes, sir.
Annexure C1. As known, these territories became part of province of Eastern Bengal and Assam in 1905 with the notifications C2.
Yes.
Assam again came under Chief Commissionership from 1921 as per notification C3. It became Governor's Province in 1921
Yes, sir.
by virtue of provisions of Government of India Act 1919.
Yes, Lordship.
These are notes. These are notes.
Yes, sir.
These are not statutes.
Yes, Lordship.
Annotations we cannot look at.
We have to.
Where have you taken this from? Which book?
My lord, Justice Ansari has scheduled, 6 scheduled books, my lord.
Very well. Just get Justice Ansari's 6 scheduled book.
Yes.
There's one in my chamber. चेंबर में है.
This history,
Oh, you are.
how these rules came.
Lushra Hills are Mizoram.
Mizoram.
Yes.
Yes. Now you come to Annexure C3. What does it say?
Government of
Exercise of the powers conferred by Section 3. So Section 3, the local government may from time to time by local way declare what enactments are actually enforced in scheduled districts or in any part of such district, declare an enactment that is not already correct any mistake or whatever. So in exercise of powers conferred by Section 3 of the GOI 1854, be taken under the immediate authority of the Governor General of India and Council and formed into a Chief Commissionership to be called the Chief Commissionership of Assam.
Yes, sir.
So that would, we are interested in only Surma Valley
Yes.
because Surma Valley and Hill District Division
Yes, sir.
comprising the districts of,
Kachar, Khasi, Jaintia.
so among others, Khasi and Jaintia Hills.
Yes, sir.
What happens to Garo?
Garo, there was a separate act, my lord. Your lordship, in the other judgment, my lord, there was a Garo, in 1869, a separate act.
That act is repealed by 1874 Act.
Yes, your lordship. That act was repealed by 1874 Act. Then there is another notification by which it was extended because we have got two administration of justice rules in 1937. One for Khasi and Jaintia Hills and one for Garo Hills, my lord, under Section 6. So there will be separate notification including Garo also under the Civil District Act, my lord.
Where are those notifications? Where is that notification pertaining to Garo?
Because your lordship, that notification is not here, my lord, but we have got adaptation order here in which that has been adapted by government in 1972, my lord. That adaptation order refers to 1937 Administration of Justice rules, my lord.
So tell us briefly the history. Just tell us the history.
Yes, your lordship. The history is, my lord, of this region is that in it, the Governor General in Council, my lord, under 1854 Act, took over the entire northeastern region, my lord, and they were declared backward tracts, and they are being directly administered by the Governor General in Council or the Chief Commissioner and later on Governor, my lord, under Section 6, my lord. Thereafter, there were three rules which were made time to time, my lord, which were governing, and ultimately all these rules culminated in 1937 rules, my lord, Administration of Justice. in Ratan Singh, the history has been traced of 3 rules which ultimately culminated in 1937 rules. So in 1937 rules, my lord, power was conferred on Deputy Commissioner to administer criminal and civil areas, my lord. Criminal and civil jurisdiction, my lord. Now, in terms of that 1937 rules, this process, the administration of criminal justice in Jantia Hills and Kazi Hills and Garo Hills were being administered by Deputy Commissioner. There was no need to issue any notification because they were having power under 1937 rules, my lord, and they continue to do it. There was one change which came in 1954, my lord, with coming of the constitution. In paragraph 4, a separate rule was formed taking away the power of Deputy Commissioner to decide the cases which fall under the paragraph 4, which says that if the offence is punishable with the punishment less than 5 years, that will be, and between 2 tribes, it will be tried by District Council Court. So 1954 District Council Court came into existence, my lord, so far as the rules came into existence for trying the cases between 2 tribes having committed offence punishable with less than 5 years, my lord. This process continued, my lord. There was no need to issue any notification. But subsequently, my lord, when the government, the judiciary was started getting separated, my lord, then the notifications were issued conferring power on district judges to exercise the power of additional Deputy Commissioner under the rules and discharge the criminal justice system in Meghalaya, my lord. And under those rules, my lord, the Deputy Commissioners were exercising the jurisdiction. One more development has taken place in the meantime. The government of Meghalaya started issuing notification conferring power under paragraph 5 also on the judges of District Council to exercise the same power which was being exercised by Deputy Commissioner, my lord. So, the Meghalaya in essence was being governed by 2 sets of rules, one under 1937 rules, which gave the power to Deputy Commissioner. After separation of judiciary in 1913, my lord, 2013, when we have the district judges were being appointed as Deputy Commissioner or additional Deputy Commissioner to discharge the criminal justice, to govern the criminal justice system in terms of 1937 rules. And finally, 2017, last notification which my friend, on which I am relying on, this is of 7th February 2017, my lord, and subsequent, my lord, of 3rd May 2018, power was conferred on Deputy Commissioner to try the power was conferred on District and Session Judge of Deputy Commissioner to try the cases under 1937. So the case was tried under 1937 rule.
When was it transferred?
Right. This was the last notification is, my lord, of 3rd May, and before that we have notification. This is of 2015. First is 10th December 2015 at page 173 and page 176 is 3rd May 2018, my lord. So
176.
Yes, your lordship. So in my
governor authorizes who?
The governor authorizes the District and Session Judge as additional Deputy Commissioner.
Just a second. District and Sessions Judge as additional
Deputy Commissioner.
And what happens on 3rd of May 2018?
Another notification was issued because the previous notification was issued by name. Another notification issued on 3rd May 2018 conferring the power on District and Session Judge not by name, by post, my lord. And my submission is, my lord, this 1937 rules.
Correcting, what was it? Page 176, what is it?
This is
correcting,
conferring power on District and Session Judge.
That is at 173, 10th of December.
Yes, your lordship.
What is 3rd of May 2018?
The another notification. And
what does that notification say?
That the notification confers the power on District Session Judge to exercise the power of Additional Deputy Commissioner under the Administration of Justice and Police in Khasi in Jindia Hills, 1937.
Yes.
So, Administration of Justice rules, my lord. Rules for
Now,
administration.
tell us, in 2015,
Just not them.
government authorizes district and sessions judge as additional
Deputy Commissioner.
deputy commissioner. Now, when was the district and sessions judge appointed in the first place in Meghalaya?
That notification, my lord, is there, and I have placed that rule, my lord. That rule is 2006, Meghalaya Judicial Service Rules, 2006, my lord, at page 112, relevant page is 123.
Yes.
And page 123, your lordship will find the table district and session judge, one post, my lord. This is of 2006, my lord. And the amendment was carried out, my lord, in these rules, which is at page 135. And the number of posts of district judges were increased, my lord, at page 141. This amendment is of 2009, my lord. Page 141, 8 posts were created, my lord.
141.
141, my lord. 28th August 2009 notification, and the first column in the table is district and session judge, 8. And the first notification, my lord,
Yes.
conferring power on district council judge is of 27 February 89 at page 164. And 170, then after your lordship will find on 10th December, which my friend has placed of Rivoi district of 10th December 2015. Then we have 12th February 2016, conferring similar power on district judge at page 174. So thereafter, my lord, similar notifications were being issued conferring power on district and session judge to exercise the power on 1937 rules and also under paragraph 5 of the 6th schedule. And the controversy which arose in Ratan Singh Milord was that Scheduled District Act has been repealed. But Honorable Supreme Court in that judgment, Milord, reading the adaptation order, held that the adaptation order saved the rules and therefore rules are in force, Milord. That is there at page 100, paragraph 19, Milord. Because challenge was laid.
Paragraph 19 of Ratan Singh.
19 of page 100 of Ratan Singh, Milord. And the adaptation order has been quoted, and in paragraph 22, because identical rules were framed, Milord, in case of Khasin Gentiles, Milord. But 19, these rules, it is contended on behalf of the state of Nagaland, continue till today. They were amended in 1952, 54, 56 and 1957. We have somewhat similar history, Milord, adaptation orders passed by state of Meghalaya, and earlier state of Assam has also adapted. In 1937, by the adaptation of Law, Order and Scheduled District Act was repealed, but there was a special saving which reads as follows. This Act shall cease to have effect without prejudice to the continuing validity of any notification, appointment, regulation, direction or determination made thereunder, and in force immediately before the commencement of Part 3 of the Government of India Act 1935. Now, after this adaptation order, Milord, at page 100(01), paragraph 22.
Yes, slowly, sir, please.
I'm sorry, sir.
Yes.
And page 101, paragraph 22. We may here dispose of one argument which is somewhat independent of others. It is contended that rules of 1937 did not survive the repeal of Scheduled District Act 1874 by adaptation of Law Order 1937, notwithstanding the saving clause in adaptation Law Order. This argument is based on submission that saving clause reproduced earlier by us did not mention rule as such. We do not agree. The saving clause preserved all notifications. Rules of 1937 were enacted by notification, and if notification were saved, the rules in notification were also saved. After the passing of Government of India Act 1935, the rules of 1937 would be successively preserved by Section 292 and 293 of Government of India Act 1935 and Section 18 of Indian Independence Act and Article 372 of Constitution. The real question are whether they are invalid for any reason to start with or become void after Constitution. And finally, my Lord, paragraph 35 at page 105. We accordingly hold that rules of 1937 continue to be enforced and govern the trial of these respondents. The Code of Criminal Procedure admittedly does not apply there, and Additional Deputy Commissioner was therefore right in holding trial under 1937 rule. Paragraph 35 at page 105. And 36, my Lord, for the sake of this, that at that point of time also, the Honorable Supreme Court said that we should have one rule, paragraph 36, one law governing the trial. 36, my Lord, we may, however, say that it would be better if, As soon as it is found to be expedient, all rules are cancelled and one uniform set of rules is made for the whole of the area. This would obviate having to find out through the maze of history and congeries of rules, notification, regulation, what law is applicable. If any difficulty is felt in making new rules, recourse may easily be taken to provisions of Article 31 of Nagaland Act, which enables the President by order to remove any difficulty to give effect to State of Nagaland, which we have done, my lord, in 2020-22 by issuing notification and extending CRPC, my lord. And at page 107, my lord, the adaptation order is there, which under paragraph section 79 of Northeastern Areas Reorganization Act, these rules were adapted by State of Meghalaya, my lord. Page 107. This order may be called Meghalaya Adaptation Law Order. It shall deemed to have come into effect from 21st January 1972. Their application to Meghalaya or any part thereof following laws, namely Rules for Administration Justice and Police in Khasi in Jaintia Hills, 29th March 1937, by mistake it is 19th March, my lord. Rules for Administration Justice and Police in Garo Hills, 29th March 1937. And these rules were adapted by virtue of section 79 of Northeastern Areas Organization Act, my lord. So therefore, the appointments made under these rules and power discharged under these rules, my lord, are validly exercised and duly confirmed. And so, in my humble submission, my lord, district judge who was authorized under these rules to discharge the criminal justice is duly empowered, and it's not a case of lack of jurisdiction, my lord. And if I take your lordship to the notification, my lord, at page 176, there are three sources of power which have been referred to in that notification, 176, my lord. In exercise of power conferred under Rule 1A of Rules for Administration, Justice and Police in Khasi in Jaintia is 1937, and further under subsection 1 of Section 2 of Meghalaya Autonomous District Administration and Justice Act 1960, my lord, as adapted and amended by Meghalaya, read with paragraph 5 of 6th schedule of the Constitution, is pleased to confer the District and Session Judge Rivoi with powers of Additional Deputy Commissioner Rivoi District for trial of all offences punishable with death imprisonment for a term not less than 5 years under Indian Penal Code or any other law for time being applicable to district, and also hear all civil and criminal revision appeals, etc. from decisions of assistant to deputy commissioner with the said district, and governor is further pleased to direct district session judge as additional deputy commissioner shall for the purpose aforesaid exercise all the judicial power of deputy commissioner with the said district with effect from the date of joining. And this supersedes all earlier notification issued in effect under the aforesaid provision with the Rivoi district. So the exclusive power was conferred on district and session judge, my lord, under 1937 rules, paragraph 5, and even under and they were duly adapted under section 79 of State Reorganization Act. And therefore, in my humble submission, my lord, that deputy commissioner or district and session judge was duly authorized to conduct the trial, and he has done so in exercise of the powers conferred under this notification. And the last, my lord, last point, my lord, even assuming some lacuna is there, my lord, the lacuna has been, without admitting that there is a lacuna, my lord, that lacuna has been filled by the recent notification of 20th September 2022, which is at page 157 of second volume, my lord. 157, my lord. And the notification saves the action taken under the 1937 rules, my lord. In pursuance to full separation of judiciary from executive and exercise of power conferred in proviso to subsection 2 of section 1 of Code of Criminal Procedure, the Governor of Meghalaya is pleased to apply the provisions of Code of Criminal Procedure 1973 to the courts in the state of Meghalaya. District Council court shall continue to derive power under paragraph 4 and 5 of 6 Schedule of the Constitution. The Governor of Meghalaya further directs that notwithstanding such application, all action taken by courts throughout Meghalaya under the rules for administration justice and police in the Khasi in Jaintia Hills 1937 and rules of administration justice and police in Garo Hills 1937 shall be deemed to have taken under the relevant provisions of Code of Criminal Procedure 1973. So, in my concluding remark, my lord, 1937 rules are applicable and the government was entitled to confer power on district and session judge to exercise the power of additional deputy commissioner and deputy commissioner to discharge the criminal justice system in the state of Meghalaya. Even under paragraph 5, governor was given power to extend or confer power on deputy commissioner or the officer appointed in that behalf to try the cases where offence is punishable with punishment in excess of 5 years, my lord. And lastly, my lord, even under the CRPC notification, all actions taken by the deputy commissioner and district and session judge under the rules for administration of justice were duly saved, my lord. And therefore, the judgment and order rendered by district and session judge as additional deputy commissioner is well within his jurisdiction, my lord.
Which is the last notification that you read?
Yes, that is at page 176, my lord.
No, after 176?
No, my lord, that is before this, my lord, because
No, after that you referred to something.
that I refer to, my lord, the CRPC notification at page 157.
Directly to Reboy.
No, after this, there is no notification.
Just a second, the 176 is pleased to confer the district and session judge Reboy with powers. Now, who is the district and session judge?
The district and session judge is the person appointed under the Meghalaya Judicial Service rules, my lord. Which
That's
I,
at page 123.
yes, your lordship, that is at page, that is yes, your lordship, because 123. And district and session judge, my lord, was appointed by virtue of Article 223.
Show us the wording by which they are appointed.
Yes, your lordship.
123
is the notification, 112, your lordship, is
112.
113,
112.
3.
So this is at 113.
Yes, Lord.
The 2006
Yes, lordship.
unnotified.
Yes, lordship.
Is pleased to make regulating the method of recruitment and conditions of service of persons appointed to the Meghalaya Judicial Service.
Yes, lordship.
Now, where is the appointment of the district and sessions judge Reboy?
That first appointment my lord, that,
Because this read with the schedule,
yes, lordship,
so many posts.
yes, so, and where is the appointment order?
Where is the appointment of
Yes, lordship.
any district and sessions judge?
I got it, my lord. The first, if I take your lordship to the order which is there, here posted, your lordship will see at page 173.
173.
But these are all conferment orders, not appointment orders.
You know, the simple point that Mr. Shanvisa is trying to make is that
Yes, lordship.
by 176, district and sessions judge,
Yes, lordship.
persona designata,
Yes, lordship.
has been conferred certain authority.
Yes, lordship.
He is saying where is that district and sessions
Session
judge?
judge appointment.
Show us where is that district and sessions judge?
Yes, lordship. That's a missing link.
Yes.
That's a,
Where is that?
that. We,
Now, it can be a factually missing link.
Yes.
Now show us legally.
Legally, my lord, 1937 rules are in place, my lord, that conferred power on Deputy Commissioner and Additional Deputy Commissioner to discharge the criminal justice in Meghalaya, my lord. Now, the powers were being discharged by Deputy Commissioner and Additional Deputy Commissioner before the judiciary separated from executive, my lord. Then in 2006, my lord, the district and session judge cadre was created, and time to time the number of posts were added and rules were changed, my lord.
Now, how is the authority of the Deputy Commissioner
Yes,
conferred? Because rules remain
in place.
So, criminal justice is going to be administered by the Deputy Commissioner.
Yes, Lord.
Now, how is the Deputy Commissioner's authority given to any district judge?
Yes, for that, my lord, these are the two notifications. The conformant is there, my lord. That district and session judge came under 2006 rules, my lord.
May have come.
And under what?
There was no sessions
Division.
There was no sessions division over here.
Yes.
Because there was no criminal procedure code
Yes, Lord.
applicable.
Yes, Lord. Now, Lordship, kindly see the rules in this regard. This 1937 rules, my lord, which is at page 9.
1937 rules, which is at page 9.
9, yes, Lordship.
Yes.
Under the powers vested in him by Section 6 of Civil District Act, the Governor is pleased to prescribe the following rules for administration of justice and police in the Khasi and Jaintia districts. This cancels all previous orders in subject, my lord. And then your lordship will see Rule 1A. The Governor may, when he thinks fit, appoint an additional Deputy Commissioner, either generally or for the trial of particular case or particular cases, civil and criminal, and may direct such additional Deputy Commissioner shall, for the general and special purpose aforesaid, exercise all or any of the powers of the Deputy Commissioner. Now, powers of the Deputy Commissioner, your lordship will find at Rule 16 at page 11. Criminal justice, Rule 16, administration of criminal justice. Criminal justice shall be ordinarily administered by the Deputy Commissioner, his assistants, and by Sardars, Dolois, and other chief village authorities of different communities. Rule 17, power to Deputy Commissioner to pass sentence in original cases and revisional powers of High Court or Deputy Commissioner. The Deputy Commissioner shall be competent to pass sentence of death, transportation or transportation up to the maximum amount provided for the offence or whipping and of a fine up to any amount, provided that all sentences of death, transportation or imprisonment of 7 years and upward shall be subject to confirmation by the High Court of Assam, hereinafter referred to the High Court. The High Court or Deputy Commissioner may call for proceedings of any other subordinate to him and reduce, enhance or cancel any sentence.
That's the authority.
Yes, that's for assistant, my lord. And then you also will see Rule 23.
Just a second. answer. Yes.
Then Rule 23, Milan, at page 13, application of criminal procedure code.
Very well. We are not doubting that the Deputy Commissioner had authority.
Yes, Your Lordship.
How is the Deputy Commissioner's authority conferred on the District Judge?
173, Your Lordship, will see now in that context, my Lord. In exercise of power conferred under Rule 1,
Just a second. 10, 12, 15 notification.
in exercise of power conferred under Rule 1, capital A of the Rules for Administration of Justice and Police in Khasi and Jaintia Hills, and further under subsection 1 of section 2 of Meghalaya Autonomous District Administration of Justice Act, as adapted and amended by Meghalaya, read with paragraph 5 of the 6th schedule of the Constitution. Governor of Meghalaya, with the approval of the Honorable High Court of Meghalaya, is pleased to appoint Srimati B. Mauri in charge District and Session Judge as Additional Deputy Commissioner, Riboi, District, for the trial of all offences punishable with death, imprisonment for life, or imprisonment for a term not less than 5 years under the Indian Penal Code or any other law for time being applicable to the district, and also hear all
And did Mauri pass the sentence over here?
No, then thereafter, my lord, the 176 is there, my lord. This time name is omitted, but post is mentioned, my lord.
Now come to the 6th schedule.
Yes, my lord.
Over here in this constitution,
Yes, sir.
just flag the 6th schedule always. Paragraph 5.
Yes, sir. The governor
Yes, yes.
conferment, conferment of power under Code of Civil Procedure 1908 and Code of Criminal Procedure 1898 on the regional and district council and or certain courts and officers for trial of certain suits and cases and offences. The governor may, for the trial of suits or cases arising out of any law in force in any autonomous district or region, being a law specified in that behalf by the governor, or for the trial of offences punishable with death, transportation of life, or imprisonment for a term not less than 5 years under the Indian Penal Code or any other law for time being applicable to such district or region, confer on district council or regional council having authority over such district or region, or on courts constituted by such district council, or on any officer appointed in that behalf by the governor, such power under the Code of Civil Procedure 1908, or as the case may be.
No. Authority can be conferred
Yes, sir.
on
3 district council,
confer on the district council,
Courts
or the regional council,
Yes.
having authority over district or region, or on courts constituted
by such district council.
by such district council, or on any officer appointed in that behalf by the governor. Is Mauri an officer appointed in that behalf by the governor?
My submission is, my lord, that,
What you are showing is conferment.
yes, your lord.
So conferment is on an officer appointed in that
Yes,
behalf.
sir. Yes, your lord.
So first the officer has to be appointed in that behalf.
Yes, sir.
Then conferment can take place.
Yes, your lord. Under paragraph
173 you are showing us the conferment.
Yes, your lord.
We are asking for how is Mauri been appointed?
Appointed, whether she has been appointed in that behalf under the paragraph 5 or not, my lord.
No. Whether she has been appointed in that behalf by the governor at all. So look at this.
Yes.
Or on any officer appointed in that behalf by the governor.
Yes, your lordship. Now, an officer appointed in that behalf by Governor, my lord, because the appointment has to be specifically saying that you are being appointed to try the cases under paragraph 5. That will be the plain and simple appointment order which can be issued in favor of any person, including district and session judge, my lord. Now, then my point is, my lord, that the paragraph speaks about conferment also, if your lordship will see.
If your 173 read,
Yes, lordship.
upon B. Mauri,
Yes, lordship.
so and so.
Yes, lordship.
But over there, B. Mauri is described as district and sessions judge.
Yes, lordship. So see,
How has B. Mauri become district and sessions judge?
even for assuming, my lord, B. Mauri is not a district and session judge. Because she is wearing two hats, one of district and session judge and one she has been appointed under paragraph 5. Because the notification says that you are being appointed under paragraph 5(1), my lord. So in humble submission,
Very good. This argument of yours will defeat page 176, where B. Mauri is not mentioned.
that problem is there, my lord. I understand, my lord, that there the officer is not appointed specifically by name, my lord.
It's a office.
Office which has been
Indicated.
Yes, lord.
Now, that office.
Yes, lord.
Show us establishment of that office of the district and sessions judge, Reboy.
Yes, lord. I'm sorry, I have got the notification, but the appointment of the office
Of the district and sessions judge.
Yes, lord.
Say for instance, this High Court was set up on, say sometime in 2013.
Yes, lord.
In March 2013.
Yes, lord.
There would have been an notification in the official gazette
Yes, lord.
saying that the High Court of Meghalaya is set up today. Pursuant to this, pursuant to that,
Yes,
all
sir.
description would be done.
Yes,
but
sir.
the effective thing is publication in the official gazette.
Yes, lord.
Now, where is this notifying the appointment of district and sessions judge Reboy?
Yes. Now, my lord, kindly see page 147. The last 147.
Yes.
Now, in exercise of power conferred under your lordship may omit the governor of Meghalaya in consultation with the High Court of Meghalaya in partial modification of rules is pleased to make the following rules regulating the recruitment and appointment of Meghalaya higher
These are
judicial
conditions of service.
and appointment, and my lord, this post have also been created.
Is pleased to make the following rules regulating the recruitment and appointment to the Meghalaya Higher Judicial Service and conditions of service.
So, and
Now you come over here to 5.
yes, sir.
Service, strength of service.
Yes.
The service shall consist of a single cadre comprising
A post
RG, district and session judges, additional district and session judges.
and exercise.
Yes, we understand this, but it does not say that every district will be headed by district and sessions judge.
Because CRPC was,
That is what we are looking for.
the fact of the matter, CRPC was not, CRPC was not in place,
CRPC was not in place.
but Deputy
Governor, otherwise the governor could have had, or any of these rules, they could have said that CRPC was never in place.
never in place.
If CRPC had been in place at any point of time, then we would trace continuity through that.
Yes, Lordship. Now, my submission is, my lord, that as on today, the position is that we have the cadre of district and session judge, my lord. They may not be session judge in a sense of CRPC, my lord. But they were discharging the functions of deputy commissioners and additional deputy commissioner under 1937 rules.
That link is not there.
Because page 173 notification says that the B. Maori is appointed, and page 176 says by post, my lord, district and session judge is conferred with the power of. So district and session judge is already appointed under these rules, my lord.
No. There is no appointment. There is a cadre creation.
And
It does not say that every district will be, see what is we have a hierarchy.
yes, Lord.
We have a hierarchy.
Yes, Lord.
We have the Supreme Court, which does not exercise administrative control
Yes, sir.
over high courts. We have several high courts. The high courts all have under 235 the power of superintendence.
Yes, Lord.
And you have the district judiciary, which is headed by a district judge.
Yes, Lord.
Now there are rules, Criminal Procedure Code, Bengal, Assam, Agra Civil Code.
Yes,
They confer the actual authority.
yes, Lord. Now, your lordship's taking clue from
Rules for conditions of service
Yes, lordship.
or creation of post
Yes.
does not confer authority.
Yes, lordship.
Authority is conferred by statute.
Yes, lordship. That is. If your lordship kindly see Article 233 also. Article
Yes.
233.
233, 234 is the High Court supremacy in district cadre.
No, your lordship, 233 talks about appointment of district judge.
Yes.
Now, the appointment of person to be and posting and promotion of district judge in any state shall be made by governor and in consultation with.
It's a consultation
So
with the
what
High
I am
Court.
trying to show me, by virtue of 2006 and 2015 rules, district judge we have appointed for each district, my lord.
No, you have not appointed. You have provided conditions of service. You have not appointed. You have recruited. You have provided conditions of their service, but you have not appointed.
Because there is no other source of appointment of district judge except for these rules, my lord. 2006 and 2015. 2015 rules, in my humble submission, says recruitment and appointment both, and then we have the schedule in which the names of the district judges are there. Now the question which arises for my answer is whether for each district we have issued separate notification appointing the district judge or not.
And whether there is any statute which prescribes his duties and functions.
The second part, my lord, because there is no.
The Constitution gives you the authority.
Yes, Lord.
The Constitution in several cases is just the authority. For instance, under fundamental rights, the Constitution says the state shall make laws to ensure these objectives are attained.
Yes, Lord.
Then you make a law
Yes, Lord.
by referring to directive principles and say that this is done under that.
Yes, Lord.
So the Constitution is the
Source of.
overarching, it's a source of power.
Yes, Lord.
But it does not directly give you the power. There has to be some act,
Some order, some notification.
some act, something,
Yes, Lord.
not notification. It has to be an act. It has to be an act of legislature. It cannot be a notification. It cannot be, it's not something which the executive can do.
Yes, Lord.
It's something that the state has to do.
Yes, Lord.
And the state over there has to function unless you show us
Yes, Lord.
that the governor has some extraordinary authority to do so. That's the problem. The problem is not so much in the notification.
Yes, Lord.
The problem is in the state not having
Appointed.
appointed, the state not having any law to indicate. Yes, accidentally, I've been deciding motor accident claims. But there has to be a Chief Justice who has to confer that authority
Yes.
on the bench to decide that. And
Otherwise.
the Chief Justice gets his authority where? Because of 229.
Yes, Lord. Otherwise.
Because of your own High Court rules.
Yeah, otherwise it will be case of quorum and judice with the.
Absolutely.
I have the appointment orders, my lord, but they are all appointment orders by.
And this is the only point that he is trying to make.
Yes, Lord.
And you look into it, if you don't have, then we have to apply some doctrine, some principle.
Yes.
Because we cannot open our prison doors and say that all of you go because your trials have been conducted by people who did not have authority.
Yes, Your Lordship.
That may not be in public interest.
Yes, Your Lordship.
So we have to find, then you have to indicate what is the de jure way
Of
legalizing what has de facto happened without authority of law.
yes, Your Lordship. Because these appointment orders which I have all those by names only, but not clearly earmarking that you are district judge of so and so, and
Not your district judge of so and so you may have said.
yes, Your Lordship.
But your district judge of so and so, we don't need to say anything because there is a law which says that the district judge will pull a rickshaw or he will drive a horse-drawn carriage. That's what you don't have to specify. But if there is nothing which says whether the district judge will be head of a temple or the district judge will become the peon of the district magistrate or the district judge will sit in court and decide,
Yes, Lord.
then
There, I would urge Your Lordship, 1937 rules, we have given him appointment as a deputy commissioner, additional deputy.
that link is not there, sir.
That is the only link, my Lord.
We'll read something in your favor. We'll try and find something out. We have to find out a solution.
Yes.
But that does not mean you don't give us an answer.
Yes, Lord, so we'll go by if, and then lastly, my Lord, even the CRPC notification has saving clause is there in CRPC notification, my Lord, which saves the actions taken under those rules, 1937 rules, page 157.
What is the legitimacy of that?
My Lord, these are the procedural.
I don't have authority.
Yeah, basic.
I don't have authority. Post facto, you give me authority.
That's it.
Today, quo warranto may not have applied, but if these facts had been brought out in course of a trial, that look, the person conducting the trial does not have authority, then he would have had to be stripped off.
Yes, Lord. Because prior to separation of executive from judiciary, all these trials were being conducted by deputy commissioner and additional deputy commissioner. But after separation, the powers were being conferred under rules 1937, my Lord, on district judges. But
Show us any that conferment of authority under the 37 rules directly, indirectly to any district or district judge. Directly or indirectly, show us. What you show us is paragraph 5.
yes, then you
There has to be something prior to that before paragraph 5 can come into play.
some rules in place in terms of paragraph 5. That's it. That's it. I need to do some more research on this aspect, particularly on this.
This is what we've been harping on.
Yes, sir.
Now do your research quickly.
Yes, Your Lordship. Any day, my Lord.
Now do your research
Yes, Your
quickly
Lordship.
so that if you don't
Day after also, Your Lordship may have it. I will. If I get some material, anything on this issue.
Day after tomorrow.
Yeah.
At the request of the state, let the matter appear on, today is the 16th, November 16th.
Much better.
That's your primary point?
That is the main point, Lordship got it.
Lordship has formulated the point. Lordship has formulated.
No, it needs to sink in for some time. You've got to think about it. And unfortunately, we have to make you win.
My work is more difficult because of it.
No, otherwise it would lead to anarchy, you know,
That's right.
we would try and be more lenient to you on the facts of the case, but otherwise it would lead to complete chaos.
Obliged.
Sorry.